Talk Shoes. Recorded live.
Welcome, everybody, to our Wednesday night conference call. This is Matthew, and I'm the moderator, and you are listening to NTT, New Trust Technology with Christian Walters. NTT is making payment under trust, which is merging titles and extinguishing debt. Welcome to the call, everybody. This is our regularly scheduled Wednesday night call at 8 p.m. Eastern Time. And before we get started, I'm going to quick read the Notice Acknowledgement Agreement. This show and our document is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure, and it is not a substitute for legal advice and or guidance by a licensed attorney. This show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communication between the parties. By reading and or using this information, you acknowledge and agree that you are not a client to Christian Walters. These documents and short recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for abnormality, commercial damages of $100 million or more per stultification or impairment for Christian Walters' discretion. Thank you for your understanding. And with that said, I would like to officially turn it over to our speaker tonight, Christian Walters. Welcome, Christian.
Hi, Matt. Thank you.
Great to have you with us tonight.
We're still going on in the Lewin book, A Practical Treatise on the Law and Trust, and we left off on page 552 of the book on the bottom, under number 11, Husband and Issue. That's page 552. Number 11, Husband and Issue. Number 11, Husband and Issue. As a child's portion is commonly settled upon the child for life with the remainder to the issue, with the limitation in the case of a daughter to her husband for life, the court regards the limitations to the issue, and in the case of a daughter, the limitation of the life estate to the husband as parts of the provision for the child, so that not only the life estate of the child, but also the interest of the children and husband are brought into the account as parts of the advance to the child. If the father covenant to settle on his daughter and her children and then makes a bequest to her children, this is a satisfaction of the covenant as regards to children of the daughter. So where under the father's covenant the children of the daughter became entitled as tenants in common, the father gave legacies to one of the children of the daughter and the two children of the deceased child of the daughter. It was held that the legacies were pro tanto a satisfaction of the covenant as to the interests of the legatees. But if a father upon the marriage of his son covenant to settle a fund upon him and his wife and the children, and the consideration thereof, and the father of the wife makes settlement at the same time, then the father of the son bequeaths the share of the estate to the son. The legacy to the son through the satisfaction of the son's interest under the father's settlement is not a satisfaction of the interest of the son's children. Number 12, slight differences. The court, from its learning against double portions, which not allow slight differences in the limitations to rebut the presumption, but slight differences are meant as such as, in opinion of the judge, leave the two provisions substantially the same nature. The cases upon the subject have generally arisen with a reference to redemption, but the rule applies also to satisfaction. In the case of a debt, as distinct from a portion, said Lord Cottingham, small circumstances of difference between the debt and the legacy are held to negative the presumption of satisfaction, but in the case of portions, small circumstances are disregarded. Thus it is that a smaller legacy is not held to be in satisfaction of a part of a larger debt, but it may be satisfaction pro tanto of a portion. However, the differences in the limitations may be so great as to negative the presumption of satisfaction in cases even of portions. If a father covenant on the marriage of his daughter to pay a sum by way of portion, and then by his will bequeath to her a share of his residuary estate, but the same will give directions for the payment of his debts, the presumption of satisfaction is negatived by the direction for payments of debts, and then portions is raised as a debt, while the daughter is also allowed to claim share of the residual. But if a testator direct payment of his debts and gives the shares of the residuary estate to a daughter, and then makes an advance upon her marriage, the presumption of redemption is not negated by the direction of the payments of debts in the previous will. Where the father is the debtor, not morally, but actually to his child, as for money advanced by the child or any other account, a bequeath of the father to the child is no satisfaction, where it would not be satisfaction as between the father and a stranger, but would be a satisfaction between strangers, will also be a satisfaction as between father and child. Number 13, contingency legacy. A contingent legacy bequeathed by a father will not be a satisfaction of a vested interest in the child under a previous settlement. 14, strangers by benefit. A stranger may be indirectly derived advantage from the doctrine of redemption, and where the testator gives the legacy to the child and the residuary strangers, and then in his lifetime advances the child beyond the amount of the legacy. Here the redemption of the legacy swells the quantum of the residue for the benefit of the residuary legatees. This arises not from the application of the doctrine, but in spite of it, and therefore the testator bequeaths his residuary equally between his wife or a stranger and his child, and then advances the child in his lifetime. Here the advance is not brought into an account so as to augment the residue from the benefit of the wife or stranger, but the wife or stranger can claim only the moiety of the actual residual. 15. Redemption and satisfaction distinguished. Redemption and satisfaction are often confounded, but one broad distinction between them must not be lost sight of. Where the will precedes the settlement follows, the settlement is the actual extinguishment of the claim under the will, but where the settlement precedes the will or gift follows, and here the settlement created a legal obligation or vested a legal right by act of inter vivos, the subsequent testamentary disposition cannot annul it, but all that equity can do is to put the parties entitled under the legal obligation or legal gift to their election. Thus, a testator bequeaths £1,000 to his daughter, and afterwards, on the daughter's marriage, settles £1,000 upon her. Here, the will is considered as revoked, and the claim under the will are actually extinguished. If, on the other hand, the father covenants on the daughter's marriage to settle £1,000 upon her, and afterwards, by will, bequeaths £1,000 to the daughter, here the legal obligation on the settlement remains, and the daughter, if she chooses, may insist on her claims under the settlement. But if she does so, the court will not allow her to claim under the will, or, in other words, the court puts her to her election. Next section, Section 2. What amount is raisable under the head of portions? This question arises as to capital and interest and maintenance money and costs. Number 1, capital. As to the amount of capital to be raised, the instrument itself generally prescribes a sum with sufficient exactness, and according to the common form now adopted in settlements, the amount graduates according to the number of children. That is, the certain sum if there be only one younger child who takes a vested interest, an increased sum if there are 2 children, and a larger sum still if there are 3 or more children. Number 2, ambiguity. Occasionally the settlement has been so ambiguously expressed with reference to the events contemplated that recourse to the court has become necessary. Excuse me. Thus in Hemming versus Griffith, the trust was that if there should be one younger child, the trustee should raise £8,000, and if 2 younger children, £12,000, and if 3 or more children, £15,000. The said portion to pay to the husband and wife or the survivor should appoint, and a default of appointment, the portions to vest in the sons at 21 and the daughters at 21 or marriage. and the settlement contained powers of maintenance and advancement out of the portions after the death of the parents or in their lifetime with their consent. There were 3 younger children, but 2 of them died in the infancy, and the question was whether the one who attained 21 was entitled to the 8,000 pounds or the 15,000 pounds. Sir J. Stewart said, "It seems clear enough that if there should be 3 or more younger children during the infancy of the 3 children, the trust for raising the 15,000 pounds were to have an operation and might be restored for the purposes of advancement and maintenance. If so, how can anything which was happened since the 3 younger children were born reduce the trust for raising 15,000 pounds to a trust for raising 8,000 pounds, only which was to be raised expressly and in terms in the event of there being only 1 younger child, and the surviving portion was declared entitled to the 15,000 pounds. Number 3, interest. The right to interest and the rate of it and from which it is to be calculated should be specified in the settlement, but in the absence of an express direction, a portion, like any other sum of money charged on land, will carry interest with it by implication from the time when the capital ought to have been raised, and this interest will in England be 4%, and in Ireland 5%. But if the settlement, while it was silent as to the interest on the portions expressly and carefully, and with all necessary circumstantiality, provides for the interest on all other charges, the presumption arises that the interest on the portions was intentionally excluded, and the court considers the general rule as inapplicable. Number 4, out of rents. In a rare case where the portions were to be raised not by sale or mortgage out of the corpus of the estate, but out of the annual rents and profits, the court, looking to the hardship of allowing the interest or accumulation for years against the income, raises the capital only and gives no interest. 5, interest given, though portion not vested, where there is a portion of father and child, or of a person standing loco parentis, and a child, the natural duty, therefore the presumed intention in providing for the child is so strong to have it led to the establishment of a particular principles. So, of these have already passed under review, and another is this: maintenance. A legacy given for a stranger and payable at the age of 21 years carries no interest in the meantime, but a legacy to a child being an infant and payable at 21, if maintenance be not otherwise provided for the child, carries interest with it from the death of the testator, and not as an ordinary legacies from the expiration of 1 year from the testator's death. So a portion charged on land in favor of a child, whether made payable at a particular age or without any direction as to a payment, will carry interest with it from the death of the testator. Next, rate of interest. But as the rate of interest is discretionary, the court has not considered itself bound by the general rule of 4%, but has regulated itself by the circumstances of each particular case. The application of these principles will be best understood by the following instance. In Ware versus Ware, a father charged the estate with portions for younger children, quote, to be paid at such time as the trustee should appoint for their better maintenance and preferment, unquote. There were 3 younger children, a son and 2 daughters. The son was apprenticed to the sea captain, and some paid to the trustees for his outfit, and the 2 daughters attained 21 and received their portions. The son died under age before trustees had named any day for payment of his portion. It was ruled that the son's portion was not to be raised, and he did not live to want it. But it was agreed that all the children were maintained out of the trust estate, they having no maintenance in the meantime, and what may have been employed for putting out the younger son was to come out of the trust estate. In Stanforth versus Stanforth, an estate was settled on the father and mother successively for life, with remainder in default of issue mailed to trustees in terms of 500 years in trust to raise 1,000 pounds for the daughter's portion, but no time was appointed for payment. The father died without the issue mail, leaving a daughter who filed her bill, leaving the mother to have the 1,000 pound raised. M.R. held, number 1, that by the failure of the mail issue, the term had arisen, though not to take effect in possession until the death of the mother. 2, that the portion vested in the daughter in the lifetime for the mother, the daughter is that presumed having attained 21, and 3, that no time being appointed for the payment of any portion nor any maintenance in the meantime, she was entitled to a reasonable maintenance not exceeding the interest of the portion from the death of the father, or at least from the time as the portion might have been raised by sale. In Beale versus Beale, it was thus. An estate was settled on the father and the mother successfully for life, with remainder to the father's brother in tail, and a power to charge portions was limited to the father. He appointed the sum of £2,000 for his 2 daughters payable at 18 or marriage, but without saying after the death of his wife, and then died. The 2 daughters who were under 18 filed their bill in lifetime of the mother and had interest of the portions until raisable. Lord Harcourt decreed that they should have an interest at 3% until they were 12 years old, and then 4% until the portions were raisable. Being dissatisfied with the rate of interest, they had the case reheard before Lord Cowper, who said that he thought the former decree was very tender and the provision there made, and that it was rather a recommendation that to the mother to make them that allowance, and the decree to change her jointer with therewith, but that since they were not satisfied, he now give them no more than what was the strict justice they could demand, and thus since the portions were not payable till 18 or marriage, he could not charge the jointress with interest thereof in the meantime. But that reason for the postponing the payment till 18 was in favor of the jointress. She ought to maintain them out of the profits of her jointer lands. In Harvey versus Harvey, the testator charged all his real and personal estate with £1,000 apiece to all his younger children payable at 21, but gave no directions to the maintenance in the meantime. The younger children, during their infancy, filed their bill to be allowed interest in maintenance. The MR said that in case where the court would do what in common presumption the father living would, nay ought to have done, in which was to provide necessaries for the children, but a court of equity would make hard shifts for the provisions of the children, as the younger children were left destitute and the eldest an infant, and the court would make such liberal allowances to the guardian of the eldest as he might thereout be enabled to maintain all the children. For the same reason, the court would likewise take the latitude in the case, and since interest was pretty much in the breast of the court, the will was silent with regard to that, yet it should be deemed that the father who gave the legacies intended they should carry the interest of the estate would bear it. For everyone must suppose it to have been the intention of the father that his children could not want bread during their infancy, but there were the estate appeared to be small, the court, in whose discretion it always lay to determine the quantum of interest, had ordered the lower interest. Number 6, general rule. It will be collected from the preceding cases that the portions provided for the children have particular quality, and whether made payable at certain age or not, and they are so far contingent as to be raisable, but to sink into the lands where the children do not live and want their portions. That is, where the children being sons do not attain 21, or being daughters do not attain at age or marry. But on the other hand, portions are so far considered vested as to carry them such a rate of interest or such allowance as the court may deem necessary for the reasonable maintenance of the children. Next, 7, costs. As regards to the cost to raise portions of the general rule as to charges applies, that the cost must be thrown onto the state and the portions bear no part of them. And of course, under the head cost, there will be included all charges and expenses properly incurred. Next, section 3. At what period the portions are raisable? Number 1, portions out of reversions. We have next to inquire at what period the portions are to be raised. Upon this subject, the great contest that has been whether they shall or not be raised while the security created for the purpose is still reversionary. The cases are unusually numerous and extremely conflicting, and the only result to be obtained by this question must be decided by the penning of the trust. Or in other words, if the instrument be unequivocal in itself as to the actual intention of the parties, the court must carry out the intention whatever may be the consequential inconvenience. A sale or a mortgage must necessarily be at a disadvantage when the security is reversionary, but if the meaning be clear that it must be done, we cannot better explain the principles by which the court is now regulated than by the statement of the two leading authorities. Number 2, Codrington versus Foley. In Codrington versus Foley, the testator devised an estate to a trustee for 999 years from the testator's decease, remainder to Lord Foley for life, remainder to the trustees for 1,000 years to commence from the death of Lord Foley for raising £30,000. For portions of the younger children, remainder to the first and other sons of Lord Foley in tail. The trust of the terms of 99 years was to apply the rents with the proceeds of the timber in discharge of certain encumbrances. Lord Foley died in 1793, leaving only one son and a daughter who became Miss Codrington. Mr. and Mrs. Codrington filed their bill to have the £30,000 raised, and it was objected that the trust of the terms of 99 years were still in operation and unsatisfied, and that the 1,000 years term was consequently reversionary, both at law and in equity, and while it was so reversionary, could not be sold or mortgaged to the great injury of the tenant in tail. Lord Eldon came to the conclusion that the £30,000 must be raised, though the terms for raising it was a reversionary, and after reviewing the opinions of Lord Cowpen, Lord Musselfield, and Lords Hardwicke, Lord Talbot, Lord Thurlow, and Lord Alvery upon subject, he proceeded, upon this general state of the doctrine of the court, it appears to me that the proper rule is that Lord Talbot states that the raising or not raising must depend upon the particular penning of the trust. And the intention of the instrument. So I do not think the court ought to be eager to lay to hold of circumstances. The court ought to hold an equal mind while it's construing the instrument. And I cannot agree with what is stated in Stanley versus Stanley, that very small amounts are sufficient. If they are sufficient to denote the intention, they are not small grounds. But they are not sufficient to denote the intention. The court does not act according to its duty by treating them as sufficient, thereby disappointing the true intention of the instrument. The rule upon the whole depends upon this, whether it was intention attending to the whole of it, and that the portion should or should not be raised in this manner. If there be nothing more than a limitation to the parent for life and with reversionary term to raise portions at age of 21 or marriage, and the interest are vested in the contingencies have happened to at which portions are to be paid, the interest is payable and the portions must be raised, and the only manner in which it can be raised, that is, by mortgage or sale of the reversionary term. 3. Collington versus Foley. In the term for raising the portions was reversionary upon another term. The trusts were unsatisfied. But with the case of Smythe versus Foley, it was reversionary upon the life estate of the father, and yet the same result followed. Smythe versus Foley. Thus an estate was limited by settlement upon marriage to R. Chambers for life, remainder to M.E., his wife, for life and bar of dower, remainder to trustees for 500 years, remainder to the first and other sons successively in tail, and the trust of the terms were declared by sale of or mortgage or other means to raise £4,000 for the younger children, the portions to be paid at the respective ages of 21 years, and of daughters at those ages of or marriage, and upon the father's further trust until the same portion could become payable as aforesaid to raise the competent yearly sum out of the rents and the profits for maintenance and education, with the power after the decease of Richard Chambers or in his lifetime with his consent to raise monies for advancement. There were 6 children of marriage, 3 sons and 3 daughters, all of whom attained 21. After the death of M.E. Chamber, the wife, but in the lifetime of R. Chambers, the younger children filed their bill to have the £4,000 raised. Baron Alderson, in giving judgment, laid down the following rules. That first, where a term is limited to the remainder to commence in possession after the death of the father, yet if the trust be to raise a portion payable at a fixed period, the child shall not wait for the death of the father before the portion is raised, but at the fixed period may compel the sale of the term. Secondly, where the period is not fixed by the ordinary settlement, but depends on contingency, the rule applies as soon as the contingency happens. Thirdly, where not only the period, but the class of children in favor of whom the portions are to be raised depends on contingency, as one is limited to take effect in the cases where the father dies without issue male by his wife. There is also on the contingency happening by the death of the father without issue male, and portions are raisable immediately, and the term is saleable in the lifetime of the father. The judge then expressed his entire concurrence with the principle laid down by Lord Ellington, viz. That the intention must be collected from the whole settlement taken together, and the finding and an express direction that the portions were to be paid at 21 or marriage, and the settlement contained nothing at variance with the construction, he decreed the portions to be raised by sale or mortgage of the reversionary term. Number 4, general rule and exception. Such are the general rules by which the court now profess to be governed, and we must, however, add the caution that when the grounds upon which the court acted in any case are not sufficient to warrant the decision upon a fair construction of the instrument itself, and independently of apart from any arguments raised or based on the inconvenience of burdening the estate, such case cannot at the present date be relied upon as an authority. And particular and special cases have occurred in which the court has refused to raise the portions out of reversionary terms. Thus, in Corbett versus Madewell, the estate was settled upon marriage on Thomas for life, remainder to trustees for 500 years, remainder to the heirs male of the body of Thomas and his intended wife, and if he died without issue male by his intended wife, and there should be one or more daughters which would be unmarried or unproved at the time of his death, then to raise portions for the daughter or daughters payable at 18 or marriage with the maintenance in the meantime. The wife died without male issue, but leaving a daughter who married, and she and her husband filed their bill to have the portions raised during the father's life. The court refused the relief asked on the ground that the portion was contingent on the daughters being unmarried and unproven for the father's death, and contingency had not yet happened. In Butler versus Duncombe, the marriage settlement limited the estate to George for life, remainder to Mary for life, remainder to the first son and other sons entail male, remainder to the trustee for 500 years upon trust, and that the trustee should, from and after the commencement of the term, raise portions of the younger children payable at 21 or marriage, remainder to George and fee. George died leaving a daughter and only issue without marriage, and then she and her husband filed the bill and have the portion raised in the lifetime of the mother. But the court denied to make any such order, as the trust was raised to portions from and after the commencement of the term, which meant the commencement in possession, and that this implied a negative, viz. That it has not been raised before. In Brougham versus Berkeley, the marriage settlement was to George for life, remainder to wife for life for her jointer, and remainder to the first and other sons entail, remainder to trustees and their heirs to raise portions by daughters payable at 21 or marriage with maintenance in the meantime. The first payment of the maintenance money to be made at such half-yearly feast as should next happen after the estate limited to the trustees should take effect in possession. The husband died leaving no issue by daughter who attained 21 and filed her bill in the mother's lifetime to have the portion raised. Lord King dismissed the bill on the ground that the maintenance was not to be raised until the estate of the trustee came into possession, and it was absurd to say that the portion should be raised first and the maintenance money should be paid afterwards. In Stevens versus Dethick, the estate was limited to Dethick for life, remainder to his wife for life, remainder to the first and other sons entail, remainder to trustees for 500 years to raise portions for daughters payable at 21 or marriage, with the direction to the daughters should have maintenance out of the premises comprises in terms, and that the residue of the rents, issues, and profits above such yearly maintenance should be in the meantime till the portions became payable be received by such persons as should be entitled to the reversion expectant upon the determination of the said term. Lord Harvard considered the latter clause to show an intention that the maintenance money, and therefore also the portion itself, was not to be raised until the term fell into possession, and he therefore dismissed the bill filed by the only daughter after the death of the mother, but in the lifetime of the father. In Massey versus Lloyd, the estate was limited to trustees for 999 years upon trust for the wife for her life, and after her decease upon trust to pay an annuity to the husband and to apply the residual of the rents during the husband's life, as the wife should appoint, a power which was executed. And on the death of the survivor of the husband, the wife to raise £15,000 for younger children's portion, and subject to the above estate was settled on the first and other sons' entail. The wife died and was held that the portions were not raisable during the life of the husband. In the case, it was a very special one, but the argument that the chiefly prevailed was based upon the fact that all the rents, issue, and profits during the lifetime of the husband had been expressly disposed of otherwise. Number 5. Hitherto we have averted only to the question whether portions shall be raised, while the terms charged with them is still reversionary. But there are still also other circumstances affecting the portions personally, and has been material bearing upon the inquiry at some time the portions are said to be raised. Number 6, time of raising portions in special cases. If a specific sum to be given to A, payable at her age of 21 or day of marriage, the money cannot be raised until the interest has become vested. For should the fund on which the money be raised is invested prove deficient, the portionist might still have recourse to the estate. And so where the trust of the term was to raise £3,000 for younger children payable at their respective ages of 21 years or days of marriage, it was held that the trustees were not authorized when one child had attained his age of 21 years to raise the entire sum, for the infant children could not be deprived of their real security for their shares, but for the manifest convenience of raising the portion at once, it seemed that the court will lean toward the construction where anything appears upon the instrument to warrant such a cause. So thus the trustees of a marriage settlement were directed after the death of the husband to levy and raise a mortgage, sale, or other disposition of the estate, and if there be more than 3 children, the sum of £10,000 for their portions, the shares of the sons to be vested in and payable to them at the age of 21, and the shares of the daughter at 21 or marriage. It is provided that no mortgage should be made until some one of the portions should become payable. 4 of the children had attained 21 and 3 under age, and the Vice Chancellor said, in this settlement there is a clause that no mortgage to be made until some one of the portions shall become payable. The whole £10,000 must therefore be raised at once. And then it is objected that some of the shares may become diminished in an amount. The answer to that is the court considers the investment in 3% consols as the equivalent to payment. And if there's any rise in the funds of the children under age, it will be the benefit of it. Next, section 4, in what mode the portions are to be raised. Where the estate is settled subject to portions, the presumed intention is that portions should be impeded as little as possible to the devolution of the property in the main channel of the limitations. Moral duties requires that the support should be secured for the younger children, but this should be done as little sacrifice as circumstances will allow to the family consequence and to represented by the eldest son. Number 1, modes of raising portions. In raising portions, therefore, it is in prima facie undesirable to sell any part of the estate, so recourse should rather be had to levy the required amount by a sidewind, and this is to produce the mines or the fall of timber, or if that can be done, then a mortgage rather than an absolute disposition, for though the mortgage is usually accompanied with a power of sale so that eventually the property may pass to the hands of the stranger, yet until the actual sale, the owner under the settlement has opportunity of paying off the charge from his private means. In every case, however, the language of the instrument must govern. If the portions be simply charged on the estate, either expressly or by implication, as where charge is implied for a power limited to the portionless of disdaining on the non-payment, the money may be raised by mortgage or sale in the case of any other charge. 2, where the sale is excluded. A trust to raise portions by mortgage will not authorize a sale, but if the trust be to levy the amount of the mortgage or otherwise a power of sale is implied. If the trust be raised the charge by and out of the rents or by such other ways and means except a sale, as the trustee may think proper, not only a sale is prohibited, but a mortgage is also which may lead to an absolute disposition. It is as it enables the mortgagee by foreclosure to get possession of the estate. Number 3, out of income or corpus. If the portions be raised by and out of rents and profits or by mortgage, here the words are ambiguous and are capable of construction that the trustees have an opinion of levying the portions either out of the income or out of the corpus, and so of throwing an onus on their discretion either upon the tenant for life or upon the remainder man. But the court will lean strongly against such a construction. In some cases, the meaning is that the annual rent should be primarily charged and that the deficit should only be raised out of the corpus. Thus, where the trustees were to hold an estate during the minority of the divisee and to raise the portions by and out of the rents and profits or by sale or mortgage, and the divisee attaining the age of 21 to pay the rents to him after payment of the portions, the court said that as the divisee on attaining 21 was to make such accumulated rents and profits only as should remain after satisfying the portions, the testator intended that the rents and profits should be first applied and that the balance only could be raised by sale or mortgage. Where the portions were raisable by mortgaging or otherwise disposing of lands or out of the rents and profits or by any other ways or means, and unsuccessful efforts have been made to raise the portions by mortgage of the property, it was held that the trustees were at liberty to apply the rents and profits first in payment of the interest and secondly in reduction of the capital of the portions. Number 4, out of rents. A more common case is where the portions are directed to be raised out of the rents and profits simply, and nothing more is said. Here, if a definite time be fixed for the payment of the portions, and ordinarily the prima facie meaning of rents and profits is taken for the inconsistent with the directions for payments at the certain time, and recourse is therefore had on the corpus by sale or mortgage. But even if the definite time of payment is not an ingredient in the case, yet from very nature of portions as rents and profits without stint represent the whole estate, the court assumes the jurisdiction of ordering the sale or mortgage, and where there is no suit pending, the trustees of an estate subject to the charge may sell or mortgage, and if they can find a purchaser or mortgagee without the intervention of the court. 5, out of annual rents only. If, however, clear intention be that annual rents and profits only are meant, the court cannot break in upon the corpus, and such is the case where the portions are directed to be raised expressly out of the annual rents, or where it is evident from the whole of context by the rents and profits were intended the annual rents. 6, out of rents or otherwise except a sale. In Bennett versus Wyndham, the trust was raised the charge out of the rents and profits, or by such other ways and means except the sale as the trustee should think proper. The court, on the other hand, collected an intention that the annual rents and profits were meant, and on the other hand, that the tenants for life were not to be deprived of all usufructory enjoyment. And the court adopted a middle course by holding part of the rents should be impounded and be part handed over to the tenants for life and referred into chambers to inquire what portion of the rents ought to be impounded and what to be paid to the tenant for life. Number 7, mines and timber. In Offley versus Offley, the term was created for raising 10,000 pounds for the daughter's portions, but the term was so short that the ordinary profits of the land would not raise above half the sum. There was an open coal mine in the land in which the court ordered to be wrought, and the powers of the trustee to make sought and drains as needed should require. the Lord Commissioner Hutchinson said that in such a case where the usual profits of the land would not be raised the money appointed within the time, the court might order timber to be felled off the land and make up the amount. 8. Out of rents by fixed annual payments. If the trust of the term be raised to levy from time to time the sum certain by with and out of the rents and profits by certain annual payments or sums in each year and not otherwise, the portional sum to be raised is the charge on the annual rents and profits generally, and the estate is not discharged at the expiration of 6 years, though the rents and profits during the period were sufficient to raise it. 9. Mortgage of undivided shares of the estate, where portions are raisable at different times as they are wanted. It is usual that each portion is raised not to mortgage the entire estate charged, but a portional part only. If the portional sum be £6,000, divisible among 3 younger children, and secured by a term of 1,000 years, when the first £2,000 is raised, the trustee for the term's mortgage an undivided third of the hereditaments comprised in the term, and when the second £2,000 is raised, another undivided third part, and when the remaining £2,000 is raised, the other individed third part. The result of this is that each mortgage take the legal estate in the subject of the mortgage, whereas if the entire estate had been comprised in the first mortgage, the 2 other securities would have been equitable and exposed to all the consequent risks. 10. Custody of title deeds. Trustees of the terms of years for raising portions as between them and the freeholder are not entitled to the custody of the title deeds and cannot deliver them to the mortgagee, but they and their mortgagees have a right in equity to the production of them for all necessary purposes. Number 11, 36 and 37 Victoria, sections 66. By 36 and 37 Victoria, section 66, subsection 34, subpart 3, all cases and matters for raising portions are to be assigned to the Chancery Division of the High Court of Justice. Chapter 18, Duties of Trustees for Sale. The subject of trust for sale may be conveniently distributed under these 3 heads. First, the general duties of trustees for sale. Second, the power of trustees to sign discharge for the purchase money. And thirdly, the disability of trustees to become purchasers of trust property. Section 1, the general duties of trustees for sale. Number 1, trustees may sell without applying to the court. It needs scarcely to be observed that trustees for sale, where there are not parties to the suit, are authorized to enter into contracts without the previous sanctions of the court, but where a suit has been instituted for the execution of the trust that attracts the jurisdiction of the court, and the trustees would not be justified in proceeding to a sale without the court's sanction. Private contracts, therefore, after the institution of a suit can only be entered into by trustees subject to the approbation of the court, and a condition is commonly annexed to the contract shall be null and void unless the sanction of the court be obtained within the limited period. Cases have occurred where, from accidental circumstances, the sanction has not been obtained within the time, and then by the death of the purchaser, the contract was dropped to the ground, and the representatives of the purchaser have not felt themselves justified in renewing it. The better mode would be to give liberty to the purchaser at the time after the expiration of the limited period, but before any confirmation by the court to determine the contract. 2, must consult the interest of the City Key Trust. A trustee for sale will remember that he is bound to his office to sell the estate under every possible advantage to his City Key Trust. In the case of several successive City Key Trusts, with a fair and impartial attention to the interest of all the parties concerned. If trustees of those who acted in their authority failed to reasonable diligence in inviting competition, competition or in the management of the sale, as if they contract under circumstances of haste and improvidence, or contrive to advance the interests of the party at the expense of another, they will be personally responsible for the loss of the suffering party, and the court, however correct the conduct of the purchaser, will refuse at the instance to compel the specific performance of the agreement. But if a trustee has once contracted to sell bona fide, the court of equity will not allow the contract to be invalidated because another person came forward and is willing to give a higher price. And if it were of two offers equally advantageous to one of which is preferred by the Sedekey Trust, it is not the duty of the trustee against their own opinion to accept the offer preferable by the Sedekey Trust. Number 3, where a sale is a breach of trust. In no case will the court enforce a specific performance of a contract which amounts to a breach of trust. Number 4. Maybe I should read that again. Number 3. Where a sale is a breach of trust. In no case will the court enforce the specific performance of a contract which amounts to a breach of trust. Might be applicable into a bankruptcy court case here. Continuing on, number 4. Sedekey Trust may contract conditionally. The usual course is said to be for the Sedekey Trust, who are persons most interested in the matter and who have the strongest motives for obtaining the highest possible price, to enter into a conditional contract and then to obtain the assent of the trustee, who, when he has satisfied himself that the sum proposed is the value of the property, sanctions a sale which is beneficial to the Sedekey Trust. Number 5, valuation of the property. A trustee for sale must inform himself of the real value of the property, and for that purpose will, if necessary, employ some experienced person to furnish him with an estimate. If the property be sold at a grossly inadequate value, it is a breach of trust, which affects the title in the lands of the purchaser. Number 6, each trustee is responsible for the sale. A trustee who takes no active part in the business cannot excuse himself by saying he has nothing to do with the conduct of the other to whom the management is confided. For where several trustees commit the entire administration of their trust to the hands of one, they are all equally responsible for the faithful discharge of their joint duty by that one whom they have substituted. Number 7, what time allowed for disposing of the estate? The trustees will be allowed to reasonable time for disposing of the estate, and though the instrument creating the trust direct them to sell with all convenient speed, that no more than is implied by law and does not render an immediate sale imperative. On the other hand, if a trust be sell at such time as in such manner as the trustee shall think fit, it will not authorize the trustee as between them and their Sedekey Trust to postpone the sale arbitrarily to an indefinite period. The trustees cannot, by such postponement, vary the relative rights of the tenant for life and remainder men, and such interfere with the settler's intention. If the trustees for the length of time, as for 21 years, neglect without sufficient reason to sell, and they will be answerable for any depreciation and be decreed to account for the interest instead of rents. Number 8, trust to sell within limited period. If a trust be with all convenient speed and within 5 years to sell the estate and apply the funds in payment of debts, the proviso is as to the 5 years is considered as directory only, and the trustees can sell and make good title after the lapse of the period. The court could scarcely impute to the settler the intention that the sale of the estate in the 5 years should be made by the court, which would be of the case if the power in the trustee were extinguished. 9, Sedekey Trust all sui juris. A trust for sale is not put to an end to by reason of all persons beneficially interested becoming sui juris, for if any one of the Sedekey Trust has a right to insist on the trust being carried out, but if they all agree to take the property as realty, the trust for sale is extinguished. Number 10, trustee for sale may not grant leases. In a case where the trustee has endeavored for some time to sell and not having succeeded, they may agree to execute a lease. The court, on one bill filed by a trustee to compel specific performance, refused to decree the lease, as the trust for sale did not prima facie imply a power to grant a lease. So the executors who are quasi-trustees for sale would, under special circumstances only, be justified in granting a lease, for such an act is not regularly within their province and is incumbent with the person taking the lease from them to show that it has been called for by the interest of the parties entitled to the property. Number 11, may not give option to purchase. The executors and administrators, equally with trustees, cannot bind the trust estate by proviso in the lease, and the leasee shall during the time have an opinion of purchasing the property at a fixed price, for it is the duty of the trustee to exercise their discretion at the time of the sale as whether the terms are in the circumstances as then existing beneficial to the City Key Trust, and on the same principle a covenant by a trustee in a lease to renew on the payment of a fixed fine was held to be in breach of trust and not enforceable by the leasee. 12. Trust for sale will not in general authorize a mortgage. A trust for sale, if there be nothing to negative the settler's intention to convert the estate absolutely, will not authorize the trustee to execute a mortgage. But where an estate be devised to trustee charged with debts, the subject thereto, upon trust for certain parties, so that a sale, though it ought to be required, is not the testator's object, the trustee may, for the purpose of paying the debts more properly, mortgage than sell. A power of sale out and out, observed Lord St. Leonard's, for a purpose or with an object beyond the raising of a particular charge, does not authorize a mortgage, but where it is for raising a particular charge, the estate is settled subject to the charge, and it may then be proper, under the circumstances, to raise the money by mortgage, and the court will support it in conditional sale as something within the power, as it is proper mode of raising the money. Number 13, where the power is left to the discretion of the trustee and the purchaser cannot question the exercise of the discretion. The testator devised to an estate to trustees upon trust to apply the rents for 15 years in payment of encumbrances charged thereon, and if for any reason whatever, in the opinion of the trustee, sale should become necessary, they were to authorize to sell. The purchaser objected, and the amount of the encumbrances would not justify a sale of the whole estate, but it was held that the power of the sale depended on the opinion of the trustees, and the fact that they thought it necessary would be evidenced by a conveyance. 14. A trust to mortgage will not authorize a sale. A trust to raise money by mortgage will not authorize a sale, though the latter may be more beneficial to the estate, and the court itself has no jurisdiction to substitute a sale for a mortgage. 15. Powers of sale. It was held by V.C. Kinserly that the absence of a special direction, a mere power to mortgage, does not authorize a mortgage with power of sale, since how can a trustee who has not in himself even any power to sell give authority to another to sell? But according to V.C. Malins, a direction of the trustee to raise money by mortgage in such manner as they think fit authorizes a mortgage with the power of sale. And accordingly to Lord Romilly, M.R., a power to raise money for sale or mortgage justifies a mortgage with a power of sale. There is no doubt in a conflict of authority. A mortgage per se does not imply a power of sale. A direction to sell or mortgage will not carry the matter further, for the trustee has no power to delegate his authority to sell. And if the broad general principle be adopted that the power of sale is an ordinary incident to the mortgage, the logical result would be that the power of mortgaging alone authorizes a mortgage with a power of sale. Of course, where the court has jurisdiction to raise money out of the estate as for payment of debts, it may either direct a sale or a mortgage with a power of sale, and the executor is, for the purpose of paying debts, regarded as an absolute owner, and may therefore either sell or mortgage or give a mortgage with a power of sale. Since the Conveyancing and Law of Property Act 1881, under which mortgagees were the mortgage is made by deed, have a virtue of this act a power of sale vested in them, the point has become particularly unimportant, but is convinced that, as by the 66th section of the Act, the power of sale in the form contained in the Act is in effect declared to be the proper power to be contained in the mortgage deed, and it cannot be contended that the power or mortgage does not now authorize the insertion of the power of sale in the mortgage deed. 16. Sale of equity of redemption. If an equity of redemption is vested in trustees for sale with the direction to apply the proceeds and discharge the mortgage and pay the balance to the settlor, the trustees, notwithstanding the direction to discharge the mortgage, may sell subject to it. 17. A power of sale will not authorize a partition. A power to trustees to sell will not authorize a partition, and was long considered doubtful whether a power to sell and exchange would do so, but it has recently been decided that under an usual power of sale or exchange, a partition can be effected, and this decision is not likely to be disturbed. 18. Effect of usual power of sale in settlements. Prior to the Settlement Land Act of 1882, in settlements of real estate and power of sale was usually given to trustees to be exercised with the consent of the tenant for life, with direction to lay out the proceeds with all covenant speed in another purchase, and in the meantime to invest them upon some proper security. For determining upon what occasions the trustees would be justified in proceeding to sale, it would be proper to notice, and in other words, Lord Eldon, the intention for the settlement is so framing the power. The object of the sale, he said, must be to invest the money in the purchase of another estate, to be settled in the same uses, and the trustees are not to be satisfied with probability upon that, but that it ought to be with reference to the object that at the time supposed practicable, or at least this court would expect some strong purpose of family prudence justifying the conversion, if it is likely to continue money. Sir W. Grant is said to have concurred in the same settlement, so that it was clearly that the trustees had between them and their City Key Trust would not be justified in selling to gratify the caprice or promote the exclusive interest of the tenant for life. It might happen that particular circumstances might call for an immediate sale, as were extremely advantageous to offer where the offer is made, or where there is a prospect of the greater deterioration by abstaining from exercising the power. But generally speaking, the trustee ought not to convert the estate without having another purchase in view, and then not for the mere purpose of conversion, but an honest exercise of the discretion for the benefit of all parties claiming under the settlement. The power of investing the proceeds upon some security in the meantime was not meant to authorize the continuance of the property as money, but only to meet the exigencies of particular circumstances, as where the trustees were disappointed of the contemplated new purchase, or the state of the title to the new purchase leads to necessary delay. 19. Effect of Land Drainage Act. It is also to be noticed that where the lands have been charged with the tenant for life under the Drainage Acts, that as the sale can only be made the subject to the charge, the exercise of the power will confer a benefit on the tenant for life, for before the sale he is bound by the acts to pay not only the interest on the charge, but also the part of the principal, but after the sale he becomes under the settlement tenant for life of the whole proceeds. Number 20, at the request and by the direction of the tenant for life, on page 585. We'll start there next time. Number 20 on page 585. So let's open it up for Q&A, and we'll have a go at it. Matt, are you there? Are we still on?
Yep, I sure am.
Okay.
Just wait for a sec.
Okay.
That you might be wrapping up here. So we ready to open it for questions?
Yeah, go ahead.
All right, folks, if you got a question, go ahead and hit *8 on your phone, and I will see you and unmute you and give you an opportunity to ask Christian a question. Don't be shy tonight, folks. Got a open line right now, so if you got a question, go ahead and hit *8. A lot of familiar names out here tonight, so hopefully we'll have a couple of people that jump on and ask a question. Okay, here's our first caller. What's your first name and where are you calling from, please? You've been unmuted. I thought I unmuted him. There you go. Is it Dyke?
Anything else? Don from Arkansas.
Hey, Don, welcome to the call.
How are you, Christian?
Hi, Don. Good.
I had a few questions. As you know, we had our first hearing for the bankruptcy, and there's some questions I wanted to discuss about that with you. The first one is, when we get ready to bring our evidence into the case, we put a motion in for an evidentiary hearing. Do we now need to send a letter to the judge requesting a specific date when we'd like to have the hearing to bring in the evidence?
Yeah, you're going to have to get a date assigned to the time. I don't know about bankruptcy court, but I suppose it functions like the other courts where you have to go to the JA and ask the JA for an opening date.
Yeah. Now, if we've already sent the opposing parties most of all of this data, are they going to need to be present at the hearing, or is that? I'm not sure exactly how that works.
Yeah, I'm not certain whether or not the attorneys would be allowed in there, but the real men and women would probably have to maybe subpoena them.
Uh-huh. Or would it be necessary to even have them present if you've already sent them the SOIs? They all have copies of the SOIs.
Well, I don't know if they'll give you an ex parte hearing on an in camera or not. So.
Oh, okay. So you can go ahead and invite them. If they come, that's fine. If they don't, that's fine.
Yeah, I would think you probably have to do a due process, and because they probably wouldn't allow ex parte. You know, everybody's so down on ex partes, but
right.
Ex parte is very seldom granted.
Uh-huh. Well,
what's that with the JA? Maybe ask that what she thought, but.
Okay. Okay. Back to the hearing for the first hearing for the bankruptcy. This was an emergency hearing that was scheduled by the DFNA, ADFNA.
Who's that now?
The Arkansas Department of Finance Administration. On Friday or Thursday or Friday of last week, before we had the hearing this Tuesday, we got a letter from the lawyer who was supposed to be doing paperwork for the bankruptcy, but who put in a motion to be dismissed as the lawyer. Anyway, he sent a letter and said, you guys don't need to show up for this hearing. This hearing will just be a bunch of lawyers gathering, and they will do their thing, and you don't need to come.
Which hearing was that now?
That was the hearing that we went to, this emergency hearing that they had called for this case. and the hearing was going to consider the motion for strict compliance and the motion for dismissal, which had been put in by the ADF&A.
Right.
So when the judge calls the case, the parties go up, and all of a sudden the lawyer for the ADF&A requests a continuance, and he had under his arm a probably 300, maybe 400 sheets of paper, a portfolio, and he handed it to Doyle, or to my brother, and he was visibly shaking, and he was red as could be. And we're not quite sure what the problem was, because he was the one who called this emergency hearing.
Mm-hmm.
But we kind of suspect that he and the former lawyer had contrived to see if they could get us not appear to this hearing, and then he would kind of take control of the situation. And because we showed up and were ready to proceed, he was visibly upset.
Right. Yeah.
Anyway.
I was going to say, I would suggest don't ever listen to the attorney when they tell you don't show up.
Yeah, well, we've kind of figured that out, that you want to do exactly whatever they're telling you to do. You better go do the opposite, because it's probably what you're going to need to be doing.
Right.
But anyway, the appointed trustee, you probably got some of the paperwork that we kind of sent to you to peruse. And I just had a few questions about that paperwork. Have you had a chance to read over it or look at it?
Yes, I did look at it. Yeah. Let's keep it on a hypothetical thing.
Okay. One of the questions that I had about her petition was, when does one need permission to transfer debt titles to a trustee? Doesn't the books on trust say that no party need to know that a trust is being formed?
Right. She doesn't really need to know about the formation, yeah. Although trustee usually is going to find out about the trust res, whether they realize it's trust res or not. That's another thing.
Yep. Well, would your estimation of this whole thing is that she's repudiating every I think there's 41?
Yeah, that's the primary thing. This whole motion is hypothetically is a repudiation of the duty to do the trust, and it is full of at-law stuff that's trying to get you to argue the at-law side, and,
right.
And really this whole thing is handing you a win, and it's giving you your opportunity to what you need and how to win it.
Yeah. Our theory is that all we need to do is go in and say, Judge, she's repudiated her position as trustee. Don't you need to appoint a trustee because a trust will not fail for lack of trustee?
Well, first of all, did you rebut this and rebut the repudiation?
No, we haven't, but we're thinking of going through and each point saying trustee is repudiating, point number one, trustee is repudiating trust position. Point two, trustee is repudiating trust.
Well, you're
position.
going to have to rebut each point in their complaint.
Uh-huh. So are you saying that we need to rebut it with a statement or do what they do, a blanket denial, or is it okay to go ahead and just say blah, blah, blah about number 4 or number 3?
Well, you could do a blanket denial.
But some of the things that she says in here are correct. They're true. Like the judge does have the ability to, as the trustee or the bankruptcy judge, he does have the ability to issue injunctions. I wouldn't deny that.
Okay, you probably have to go through and pick out certain ones that
She did a very good job of laying out the entire foundation and all the background information for setting up the trust.
She's really in there trying to wiggle out of it and do it by disclaiming.
Uh-huh.
But on your page 2 there, we're stating the instructions.
Yep.
Right in there, they're talking to you and telling you right off the bat what to do there.
Number 2.
Page 2.
Uh-huh.
Says the filing of a bankruptcy case creates an estate under the jurisdiction of the bankruptcy court, which consists of all the property of the debtor wherever the property is located. Because the bankruptcy estate is so extensive and the jurisdiction of the court so broad, there may be lawsuits over the property or property rights of the estate. And when there's an or, it's either one or the other.
Right.
So which one is it? Are you going to claim the property rights of the estate, or are you going to fall into the trap about the lawsuits over the property?
Well, definitely. We're going to go for the rights.
Right. So there may also be lawsuits concerning the debtor's discharge, and if such a lawsuit is filed in bankruptcy court, it is to be called an adversary proceeding. So she filed an adversary proceeding.
Right.
But what she's doing is she's giving you the win on a silver platter.
Mm-hmm. On the issue where she's complaining about having been assigned the debtor position, we understand that was a minor error on the UCC1 filing where...
Yeah, because I was going to ask you whether or not you had a non-UCC filing and whether or not you had the nomenclature change block put in there.
We went back and looked, and sure enough, it's not there. And the reason is that we did this online, and it's probably one of those blocks that we missed. We did the filing online, and it's kind of easy to miss that. So that's been corrected. We corrected that today.
Okay.
We canceled out the old one and refiled. So I don't know, will that negate or make moot her complaint about that aspect of the filing?
Yeah, because as a UCC filing, that has her down as a debtor.
Yeah. Well, that was just an oversight.
All right, well, you could say you corrected that, and that would knock that out. My question was, do you have the case incorporated as the trust?
Yes.
You do? Okay.
Yeah, there's multiple trusts going on here. We have the trust with the ADFNA. We've got this one as a trust, and we've sent all of went to the JA, I guess you're calling her, and asked her to photocopy all of the documents that had been filed into the case, which were mostly from the ADFNA, and then she certified them. We got certified copies. We endorsed them, as she said in the paperwork here. They are endorsed instruments, and we sent them to her for this case. Now, the ADFNA has also had a trust expressed upon them as well, and we kind of suspect that the lawyer was so upset the other day because he now realizes that he's in a pickle because they have poo-pooed all of the trust documents that have been sent to them and actually put the documents into the public as part of their exhibits in some of their pleadings.
I would be sure to object to that because you want to keep, from what I can see, that's a little bit too much private nature exposed in the public, and I would be definitely objecting to it.
Mm-hmm.
And possibly you might want to put a protective order on this now to get that sealed, so that can't be spoken about in any greater detail than what it's got so far.
Yeah. Well, we've written up a protective order, do we need to write a motion and put that into the case to request that it be sealed then?
Yeah, I would, just to make sure that the nature of this is going to be protected, and that's what a protective motion is for.
Is he going to want, well, now he's already gotten the SOIs, so he knows, this judge knows what's going on. And in fact, at the hearing the other day, there was another case that came up just before this one, and it was a trust case. And he issued an injunction or a preliminary, an injunction to the defendant. A bank was trying to raid a trust to get as much information as possible, and he was telling them that he would not give them a carte blanche, go ahead to go through all the paperwork or all the documents of the trust, and was using all this trust terminology like an injunction and can't remember now all the other details, but it demonstrated that he knows trust.
Right. Mm-hmm.
So we kind of figure that he's well aware of what's going on with this case because he's received the SOIs. And we sent the SOIs because we went, Tuesday morning prepared to express the trust.
So
now,
the case itself is like the main trust, and it's incorporated this ADS or whatever that thing is.
yes. And in fact, the other creditors have also been, trust has been expressed on them. They're not very many, but the creditors' meeting won't occur until October 20th. So we really won't know who all's going to show up for the creditors.
What you're trying to do is take all your other bills that people were suing you for, turn them into trusts, and then incorporate them and stick them into the case as being a trust, and fold them in on one another.
Exactly. And we're doing one big trust to
one trust.
One trust to encompass all the little trusts.
Now, this trustee thinks that there's two trusts here, apparently, and she's trying to wiggle out of the one trust and try to get you locked into arguing the statutory trust. And what I would have done was withdrawn the statutory trust, the Title 11 bankruptcy, the case, withdrawn that and special deposited that back in and turned that into a private trust.
Well, that's kind of what we did. That's the debt titles that she got. She was instructed to withdraw and redeposit as special.
Right. So now you no longer have a statutory Title 11 trust that you're going by those rules.
Exactly.
So now I would counterclaim this. And that counterclaim would put you into equity. And as long as you didn't argue her merits and her complaint,
right,
and you stuck to your counterclaim, what you put in your counterclaim and all that, everything you put in your counterclaim would be nothing but equity.
Right.
Then that should be heard first before this complaint.
Now, when we go to the hearing, which complaint or counterclaim is going to be heard first? Because this is a suit.
Well, they can't hear the complaint first. They got to hear your counterclaim first.
Well, now we have a counterclaim filed into the bankruptcy case, and then this would be the second counterclaim on her adversarial claim.
Right. You got to counterclaim her complaint.
Right.
You got to move her complaint and leapfrog it with equity instead of her at-law stuff.
Right.
That's what I would do.
Yeah, and my question would be, now when we come to the hearing, which complaint gets heard first of the two counter-complaints or counterclaims? The bankruptcy or the adversarial?
That I don't know, whichever one you set up.
Well, we've already got the counterclaim in for the bankruptcy. That's one of the reasons we went ahead, and it had the, apparently we didn't get it filed soon enough before the hearing. Had the counterclaim appeared upon the docket, to be heard, then yesterday we would have gone ahead instead of letting him, he requested a continuance for November 17th, I think it is. But had the counterclaim been on the docket, then we would have gone right ahead and expressed trust for Tuesday.
Okay. However way this plays out is you're either going to get into equity, maintain equity, and you're going to win, or else you'll lose by getting the introduction in here to argue their complaints under the at-law side.
Yeah.
If that happens, you'll lose.
Well, if we don't put anything of the at-law stuff in our complaint and keep it totally in equity,
yes.
They can't force us to talk about their complaint, can we?
Not if you're talking about your counterclaim first and you've got nothing but equity in that counterclaim and you're going to talk solely about what's on the four corners of that document, then that leaves everything else that's at law out of it.
Mm-hmm. Okay.
I'm glad to hear that you said you had the case as the main trust and you withdrew that one, because the way she had it worded here, that it kind of was misunderstood to be there was like two trusts here. That would have been a fatal mistake.
Could you point to me what page that verbiage is so I can go back and study it and make sure that. I'm not exactly sure where. Now,
I remember exactly where it was at, but
now she repeated some of the counterclaim because we did an amended claim. We decided that it wasn't correct as we wanted it, so we did an amended claim. Now, I don't know if that might confuse the fact that it sounds like a second trust.
See, those notices those were okay when they brought them in there, but the one I don't like is on page 3 there, where it's talking about the claim and the debtors have asserted, among other things, that, and then they more or less put your instructions in there, which was your indenture talking about the extinguishment of debt.
Well, she also put a word in here that we didn't put in the original verbiage, and that was bond. Did you see that?
No, I didn't. I kind of assumed that that's what was there, but
we don't recall putting. I have to go back and check the paperwork, but I don't. There was no reason for us to use the word bond. Well, anyway, so we just need to go back and reject all the repudiation, and then do a counterclaim and bring it all into equity and put her on notice that this is a private trust. She's got it all. She thinks it's all done in public, and she's saying that we can't transfer property to her because she's only a Chapter 13 trustee.
Yeah, that kind of raised up a thing. Of course, we didn't know that when we did this, but maybe it might have been wiser to use the U.S. trustee instead of one of the sub-trustees.
How would you... Could we ask her who the U.S. trustee is? Would she tell us that?
Yeah, you could ask her. She should tell you. If not, it's public record.
Uh-huh.
For whatever district.
So you think it might be better?
Like in the same trust, and you got all the trusts converted into one trust, which would be the main case, and now you got, say, of all the creditors, each one of those individually are going to be co-trustees, and then the court, whoever's the main trustee there, probably would be like the main trustee.
Yeah.
Now they're all linked up in this together. When you equity have that issue, that mandatory injunction, get the performance that they're supposed to extinguish the debt, and now they've got to.
Yeah. Well, that's the direction we're wanting to take this, is that we want to encompass everything under one umbrella, that being the bankruptcy court, and get permanent injunction from the court to have them compelled.
So, like, that ABC company was the one you owed. So that trustee on that would be one trustee, and then this bankruptcy trustee is the other trustee. And then if you had more debts, then those others, they would also be trustees, co-trustees.
Right. Yeah, that would be all the CEOs and CFOs of all the companies.
Right. What? So then order out of the issue of the court of equity to extinguish the debt, that's going to cover them all.
Yeah.
Now, I have a question. Did you have a caveat in there of the effective date of the trust, or in effect telling her that she had so many days to disclaim?
Yes, I think we gave her 10 days to disclaim.
Okay, good.
And she's still holding the trust res. We talked to her, and
that's where I was going next.
Yeah.
Now, I would send her a confirmation letter of her acceptance of the trust.
Uh-huh.
And tell her that the trust is now on that specific date, the 10 days that you gave her, on that 11th day, on that date, that the trust became effective, and you are now acting as trustee, not bound by the terms of the indenture.
Yep. We also, she sent a bill for the, they set you up on a payment schedule, and she promptly sent a bill for the first payment, and we promptly endorsed it and returned it to her office for extinguishment as a special deposit. She would have gotten that today or yesterday morning.
Okay. All right.
So.
Something else. I forget what it was. Anyway, that was the biggest things I had. But I might want to talk to you more privately. Maybe we could talk a little more in detail.
Okay. Well, perhaps we can do that on Skype or something.
Yeah.
Okay. Well, I appreciate it. Your input. At least we were thinking along the same lines that you suggested that we go.
Well, when you got this, what were you thinking?
Well, we asked her to her face, are you repudiating your position as trustee duty?
Did you do that in writing?
We haven't yet, but we asked her yesterday when she said that she was filing an adversarial claim. And we asked her, are you repudiating? And she was taken aback. She took her, a few seconds to respond. But yet she repudiated even with her response.
Yeah, because we went over before, I think I've said it, Book 90 CJS, Section 422. And that basically said that you can't be holding trust res and disclaiming at the same time.
Right.
Now, in the counterclaim, I'd asked that equity would look through the form, process, and procedure into the substance of the matter and grant you a relief to say, well, I have to think about this, whether or not you want to strike their claim.
Well, would it be a good idea to go ahead and convert this into another trust and do a claim on it, claim all rights, titles, and interest to this?
No, I don't think you have to, because everything in the case that's in there, any document-wise, is automatically incorporated into the case, and that is the trust. So.
Okay, so it's all drawn in. Okay.
But I don't know. What were you thinking when you got this? So you were,
To be truthful, expecting it, because we know how these lawyers operate. Deny, and repudiate.
Because on first glance, everybody would look at this and say, you'd probably say, "Oh man, this is another headache I got to fool around with," But really, when you read it and you get into it, if you know what's in it, really they're giving you the win on a silver platter here. They're actually creating the avenue that they must give you. But now the choice is up to you whether or not you're going to choose the outlaw side or you're going to choose the equitable side. If you choose the equity one and maintain it in equity, you're going to win.
Mm-hmm.
If you fall into the trick and the trap and do the benefit at law side, you're going to lose.
Yeah. Well, we're definitely not interested in doing the at law stuff. No way.
So anything else on it there? Well, I mean, we talk about it later, but anything in general?
I think we covered most of my general questions. Let's see.
I thought it was very interesting on the cover letter there, the nature of the suit, and all that big block there with all those, 20 different blocks that you could check. Not one of those blocks was checked.
Exactly.
And then down below, that next line there, it says on the left, it says, check this if case involves a substantive issue of state law. That one was checked.
Yes, I thought that was very interesting. And up here it says trustee. Yep. Well,
and the relief sought is blank, and the demand for the amount of money is unknown.
Unknown. We are in it.
These people don't know what's going on.
I think they think we don't know what's going on.
Well, that's probably the true statement yet.
I think the attorney for the ADF&A is starting to get a little worried. High blood pressure. His blood pressure is starting to be a problem. It's really.
They need to extinguish the debt per the order of the court out of Court of Chancery Equity. All they can do is just get it back on the back end when they do the write-off. They'll get it back off the tax.
Yeah.
So they'll get paid. There's no worry about that.
Right. Yeah. I want to ask running on that new application for the new owner special deposit Oh, next question, Christian. The application for the business was sent in, for the new owner was sent in July, and they had ignored it. And then they sent a letter here recently stating that Friday that if send in a payment and send in some other information and send in a verification of the lease and all this stuff, that they would issue the new license. Well, it also states that whenever you close a business or you transfer ownership to another business, all the taxes have to be paid up. Well, now, if they're going to be issuing a new license all of a sudden, does that not mean that the taxes have been paid?
I would assume so.
Well, that's kind of what we're thinking, because we've sent the debt titles have also been sent to the IRS, with an indenture with our friend Miss Doon, and we're kind of suspecting maybe the IRS is also kicked in on this as well. So it may be, now if that be the case, if we go in and the ADF&A say, well, we don't have a claim here anymore, can we not still continue with the bankruptcy and do all those other trusts? Or I'm assuming that we could. But
I'm not quite following you. What do you mean there?
Well, say the IRS goes ahead and clears up or extinguishes the debt that the ADF&A says is outstanding. So that's the major force behind this bankruptcy. Would it be prudent to go ahead and continue the bankruptcy and take care of all these other trusts as well?
All these other trusts? You mean
all the
other trusts out there that you haven't incorporated into this case?
No, that would be all the other creditors that are involved in this case.
Right. Get them all at once.
Yeah. Okay, so just because one steps out doesn't mean all of them do.
Well, how did one step out?
Well, I'm just saying hypothetically. If the IRS comes through on the debt titles, then that would exterminate the claim, would it not? They wouldn't have an issue.
Yeah, there wouldn't be any amounts due. There wouldn't be any controversy. The case would be, in effect, you paid it all.
What about their breach of trust?
Well, that's your leverage point, because how long did you give her to perform this extinguishment of the debts?
Now, the 13 trustee has been given 10 days. Now, the ADF&A, they have, now for a couple of months, have poo-pooed the paperwork and called it paying debt with monopoly money and call it some other derogatory names.
Okay, now I treat that as two separate breaches now.
Okay.
Breach against one trustee, breach against the other trustee.
So this is the reason we kind of think that this lawyer is upset, because he's now realizing that he's kind of caught in a crack. And
yep.
the trustee, the 13 trustee said, I don't know what you're doing here. I don't recognize this paperwork.
Tell her to get a lawyer.
Well, she said she had a lawyer, and her lawyer had prepared the paperwork.
Okay.
They don't know NTT.
Okay. Anything else?
Well, Dole, let me ask you if you had any thoughts about why they might have put it off for another month.
Without looking at what you had so far put in there, I'd probably say they probably have to give you like 30 days to get timed out so they could go on to the next step, because everything operates in 30-day cycles.
Now, whenever it comes close to the time for the next hearing, should we not resubmit our SOIs?
No, if you've got them in there already, I think you're covered. But if you don't have them in there, then that's probably the reason why they reset it for us, say, another 30 days.
Huh? The SOIs were sent to the judge in private. Now, do we need to go ahead and do the evidentiary hearing to get it done, put the SOIs officially into the folder?
Yeah, you got to get the evidence on the file, so you got. But I think you're going to need a protective order just to make sure that you can get into an in-camera hearing.
Uh-huh. So what I'm interpreting that to be is that we need to put a motion in for a protective order. We went with all our orders written up when we went to court the other day. We have all our orders ready, just for the judge to sign. But we need to file a motion for protective order, and then we have a motion. Did we?
Yeah, then put in a notice of hearing.
Okay, so we did put in a request or a motion for an evidentiary hearing. We have not yet. We wrote up a order for a time, and we were going to have the judge to give us a time. So I guess you're saying that we should take that and have the JA give us a date?
Yeah, you need to ask her for the date of the hearing. She's got to set the hearing.
Okay.
This one's the in-camera one.
Yeah, that would be for the evidentiary hearing. We need to invite the adverse party.
Here's where they may say there might not be any necessity for. We don't see a necessity for an in-camera hearing. And
the response would be that, well, this is a special matter. You've got evidence of it.
Yeah, well, that ought to be in the motion that you're asking for the hearing.
Okay.
And then the protective order actually sets up the nature of the thing because it's private, and you're trying to protect it. And your protective motion is your manifesting your intent to keep it private,
yeah,
which actually sets up the need for the in-camera private, hearing.
Right. Okay. So the motion for the protective order should include the mention of the private elements, or this is a special matter and requires special handling.
Yes, yes. Were you on a call last night when Eric was reading?
Yes.
Okay. Because actually we talked about some of this stuff.
Right. Yeah. It went on endlessly, but yes, we were listening. Well, I think that's all the questions I had related to this issue. We'll try to get with you on the Skype and do some of the more detailed things here.
One of the little finer points that I discovered recently was that when you claim the right, consecutively with it, you have to claim that there's another party that has the duty that corresponds to the right.
Okay.
So you got to show the right, and you also have to show the duty. So show that somebody owes the duty.
Uh-huh.
That has to be done simultaneously.
Okay.
It's like an unbroken chain comes back down to, which finally you get to the point where, well, it's the indenture that sets up the whole thing, but it's private, and you can't have it be seen in the public. And I'm putting a protective order on it, and that protective order says that it's private, and that's how we're keeping it. And I want an in-camera hearing, and this is why we need the in-camera hearing.
Uh-huh.
This is an in-confidence relation.
Right.
And I've relied upon that to be kept in confidence. And that's my right. And if anybody makes this public, they're going to be violating my right to keep it public, or private, I mean.
Uh-huh. Okay.
I have an equitable right to keep it private.
Okay. Well, I can do that. I can type that up.
Then make sure you got the test for the trust in there.
You mean on the one that we've expressed with?
Yeah, so the judge can't say, well, I don't see a trust, you know. Well, sorry, Your Honor, here's the intent, here's the purpose, here's the parties, here's the specific trust res, here's the method of delivery. Now, you mean to tell me that this is not a trust?
Now, could that be put in as a SOI, a written up statement? Or a notice, I guess?
Yeah, that would probably be like on a motion, and that would contain the claim, and the SOIs would be attached to it. But as far as the specific details, say, of the indenture, I'm just going to say in that motion that an indenture was created on such and such a date. It was sent to the trustee. It did mention intent, purpose, party, specific res, and it was formed by mail delivery on such and such where trustee got received of trust res.
Right.
But yet there's no specific details as to what the indenture said, because that's the private nature of it, and that can't be revealed in the public.
Right.
But yet that is the test for the trust right there, just what I mentioned, and there's no way that judge can say, you know, I don't see a trust.
Yeah. You've got it all there in black and white.
Yeah, now I'd ask him for a ruling on, you know, do you see a trust? You know, because if we got a trust, you know, we're off and rolling now, because you just basically go for one then.
Right.
Because now the burden shifts on the trustee, and we want to know whether or not he did the extinguishment. Otherwise, the breach of trust is going to stand.
And it will become her responsibility to...
Now, if you have that in the counterclaim, then why are they not doing the extinguishment? Because they're in breach of trust, and now they probably commingled, because I don't know where the funds went to. And now we should come down to enforcing this breach of the trust and finding out where the funds are if they don't do the extinguishment. And we're going to do some tracing and find out where the funds have been converted and where they went to.
Right. That would include putting the trustee in receivership, appointment as trustee.
Yes, the trustee and the receivership, yeah.
Huh.
And any time that they're going to argue anything at law, I would object and say, where is that in my counterclaim?
Exactly.
We can't talk about anything outside other than the existence of this trust, and there's a breach of trust, and when are they going to do the extinguishment?
So whenever they get off of those topics, then they're outside of the realm of this pleading.
Yeah, and as soon as they open their mouth in that in-chambers hearing, I'd be objecting that they're acting as attorneys, which can't be heard at this hearing.
Right.
Your Honor, if that attorney opens his mouth again and talks anything about an attorney at law side, I want you to gag him. Because I doubt very seriously have any equitable claims or any equitable claims against you at all. They can't. It's impossible. So there should be nothing said on their side, on the at-law side.
Well,
you get into in chambers, that should be solely be your hearing, and nobody else should really speak of anything. And it's only coming down to the thing, well, here's, do you see the trust? Yes, if you see the trust, all right, now let's go on to when is the trustee going to make the extinguishment of the debt? When am I going to get the performance?
Right.
I want a mandatory injunction to force them to do the performance.
Now, if we had expressed the trust at the hearing on Tuesday, would it have been necessary for the trustees to be present, or could that have proceeded without them?
Yeah, I could have proceeded without them, yeah.
Okay. So they don't need to be present.
No, because that's all the judge has to do is recognize there is a trust in existence.
Uh-huh. Well, it's getting interesting. They're getting nervous. Nervous from that as hell.
Okay, well, hang in there.
Yeah, we'll do our best. We'll definitely keep you posted.
So try to get with me so I can talk to you some more about this. So.
Okay. We'll kind of hang out. We kind of watch the Skype group pretty closely. When is the best time? I think evenings, late evenings is probably the best time. Is that correct?
Right.
Well, maybe we can catch up with you later this evening if you want to.
Won't be this evening.
Okay, that's fine. No big hurry. We'll be answering. We'll probably want to kind of discuss some of the, whenever we answer this adversarial claim. I might want to run it by you before we push it in.
Yeah. Try for like Thursday or Friday here.
Okay, that's cool. We can do that.
Okay, anything else?
No, I think that'll do it for now. I appreciate your input.
Okay, we'll move on to the next caller then.
Okay, thanks.
All right, thanks for your questions. Those are great questions. The next caller, San Greta Grotto. You have been muted. Go ahead with your question.
Hello, good evening, Christian. How you doing?
Okay, how about you?
Not too bad. A great call. That last caller had some good practical, real life stuff going on. I'm looking back at a standard deed of trust, like in a non-judicial state. I'm looking at the wording in the deed of trust, and I know I made a general deposit and regarding this thing, and I know it's a debtor-creditor relationship on my end. But when I'm looking at the way the trust deed is written, there's just I'm just really confused. There's some contradictions. They're saying MERS is the beneficiary under the instrument, and a beneficiary usually holds the invisible equitable title, if I'm not mistaken. Yet a couple paragraphs later, it says they're holding legal title. So, and then there's a transfer of rights clause where it says borrower irrevocably grants and conveys to trustee in trust with power of sale the following described property. So I'm just confused because if they're claiming MERS is the beneficiary under the deed, then they should be holding equitable title of the debt title of the deed of trust, but yet then they turn around and say the trustee's holding title, and now I'm not quite sure who supposedly owns equitable title of the deed of trust of the debt. So I don't know.
Well, I can say that I'm Santa Claus, but that doesn't mean much unless
I know. I hear you. I understand. It's still construed as a general deposit, and they can kind of do what they want. But I'm just trying to make sense of their own trust instrument. And it's not making it.
Yeah, I think you need to go read the Kansas City case involving Mears, because in that case it pretty well explained the whole thing, because the court basically said the same thing. They were confused also. How could Mears be this as a beneficiary and also having legal title and blah, blah, blah. But in effect, since that case, been other cases since then that have effectively turned Mears into vegetable soup.
Oh, definitely. But unfortunately, they still have they still have some power here in California. I know.
Well, I think at this time, effectively, Mears is dead.
Right. Well, nobody works there. It's just a dummy corporation. It's just a straw man corporation. They don't have any employees, really. It's just
well, one thing to do, what I would do would be I would come in there and Mears is the nominee. It says usually that in the security, and I forget what it says in the warranty deed. But I would fire Mears, and I would make it publicly noticed.
Right.
Put it on the record in the same place where they recorded the deed there.
Yeah. Well, the county recorder's office, I can't get anything like that recorded, but I found a local newspaper just down the street from me, and they will, for a fee, post whatever you want in their publication, and they even issue an affidavit of publication. So that could be my SOI going around the county recorder,
right?
And I could still have my UCC1 at the Secretary of State as the other witness, and kind of go around, because they're the county recorders here. If you're not a financial institution doing something regarding real estate, then they don't want to record anything. So.
Well, I would use this Mears issue to open up a can of worms about as big as a football field, and I would drive this right down the throats of those county suckers, that I would make them vomit their own puke.
Yes, that's now you're speaking my language.
That's me, but somebody needs to go do that.
Right. No, I hear.
You've got a lot of court precedents behind you that you got the right to fire these people. Now,
right.
You mean to tell me that these county agencies will not record that? Well, I'd slap you with a lawsuit so fast it'd make your head spin.
Amen, brother. But even regardless of the fact that the county recorder, I'm looking at, if I want to do my UCC3s and withdrawal from a general deposit and redeposit, I'm just trying to get it straight who I'm withdrawing it from. I know where it's going to go as a special trust deposit, but according to the wording in this thing, I'm completely confused on who owns what. According to my deeds,
well, that's what was determined in the courts. Mears doesn't own anything.
Right.
Mears has no rights at all.
Well, on the debtor-creditor side, because they haven't lent any money, but in trust, there needs to be no consideration, and if they're named as beneficiary in the deed of trust, then it doesn't matter who they are, right?
That was proven to be a fraud.
Okay. All right. So that's one of the methods of revoking a trust is fraud.
Yes, yes.
But then isn't that a heightened pleading? And I got to prove that somehow?
Yeah, it would be if you're going to come out with fraud, yes.
Right. But fraud in equity, is that a heightened pleading as well, if I can prove a trust? Or is that just a breach?
Well, statutorily wise, it requires a heightened pleading, but under equity, you may have to do the heightened pleading to get it to look like so they wouldn't complain. Otherwise, you might not be able to get an equitable hearing for it. So,
well, I'm just kind of juggling the options. I already have my indenture written. I've already got my UCC 1s and 3s done. I can get my second witness at that local publishing newspaper place. That's no problem. But what I found out doing my hypothetical research on this hypothetical case, that there is no so-called investor, there is no so-called owner of the loan. I've done title searches, high and low, nothing in the county, no assignments of deed of trust, no nothing. I mean, I don't know what happened. I don't know if this is one of those Chinese loans that went nowhere. I have no idea what happened, but
that deed that you got from the county, that was the result of your equitable conversion that you allowed them, or you authorized for them to do at the closing there. But in fact, that was one of 3 equitable conversions that run simultaneously.
Right. So you got the trust I formed with the county, and then the deed of trust with the trustee and the title company and all that. And then the third one is was that the promissory note?
Yeah, there's 3 of them. I forget what the third one is now.
But now if we
your beneficial interest got converted to the bank at the signing of your contract for the purchase of the property. You
on the asset title.
You got the beneficial title at that time, but then when you got the loan, you converted that beneficial title, and it was equitably converted, and now the bank's got that.
So on the asset,
the seller got the title that you were supposed to get, the possession or possessory title, the deed, was then converted into the county, so you don't get that one either. And then there's the third one. I think it involves the note. I forget exactly what that was, but you wound up with the whole nothing, which was the debt, and you wound up with nothing, but yet you got the whole debt.
Right. No, I'm aware that I exchanged all this stuff for a debt.
So there were 3 equitable conversions happening in that whole mortgage process.
Right. I'm just trying to map it out.
You authorized. Now, if you authorized it, you got the power to shut it off.
I agree. Now, is that by virtue of mistake, in addition to removing from a general deposit and redepositing as a special?
Yeah, mistake and
undue duress, fraud, and I think there's a fourth one.
Yeah, you're mistaken intent.
Okay. All right.
It was a mistake. It was not my intent that it went this way.
Right. Well, I sent an indenture, whatever I had preliminarily, just kind of just to test the water. I sent it to the foreclosure mill, and they sent me back a big packet and a 3-page letter basically screaming at me. And which was surprising because I've sent these foreclosure mill attorneys' offices things before when I was doing the debtor creditor stuff, and never heard a peep back from them. But as soon as I put a duty on them, they responded right away. But that's all I was wondering is I'm just trying to reconcile in my mind, what I know about trust and compare it to what's actually written in the indenture, and it's totally incorrect. Unless Gilbert's and CJS and everything else is wrong, but I highly doubt that.
Well, you have to make decisions to back that up also.
Right.
Because that's what the courts decided. This was all a fraud.
Definitely. Well, it's all over the mainstream news even. But now if on the at-law side, if they can't determine who the supposed lender is or who allegedly has the beneficial interest in the note, if that can't be determined, is it okay to do a quiet title action on the legal side, on the at-law side, and then do the NTT at the same time on the equity side?
Yeah. Mm-hmm.
Okay, so you can have those simultaneously going on at the same time.
Yeah, quiet title to reconvey the deed.
Right, because I don't think anyone's going to step up and make a claim on this note, and I don't see why I can't push a quiet title action right through.
It's impossible that anybody's going to step up to the plate to counter what you're claiming, because the owner, the note and the security agreement have been bifurcated. They've been separated. There's no possibility that anybody can step forward because nobody knows what the owner is, who the owner is.
Right, but in my case, which is slightly different from many others, if there's some sort of a securitized indenture trustee, like say Deutsche Bank or HSBC, those guys are coming.
That's proof that has been bifurcated and it's been separated, and then nobody can foreclose.
Right, but there doesn't seem to be any indication that mine is in any of these securitized trusts. I've looked.
Well, you need to hunt around, because the chances are today that anyone didn't securitize a mortgage in today's times is between slim and none.
Right, that's true.
You can bet for sure that your mortgage has been securitized somewhere. You just need to find it. I'll tell you how to look for it. Have you got your security agreement? Check for the MIN number, the MIN number on it.
Yeah, I got it.
All right. Go to Mears' website.
Uh-huh.
And let me see if I can tell you what it is.
I think I've done that. It's you type in the MIN number. It's supposed to give you who the supposed investor is.
Yes, you get three options to search by. You can search by the MIN number or the name or whatever it is, but I usually search by the MIN number, because you can, the MIN number is there. Punch that MIN number in, and it'll tell you who the servicing agent is and who's the owner of the note.
Yeah, it's called the MERSServicerID.org, and
right.
It says search by MIN, search by address, search by FHA, blah, blah, blah. I did that. I typed in my MERS number, or my MIN number, and it says City Mortgage is the servicer, and then it says the investor chooses to remain private. That's what it said. It says it does not wish to disclose. So...
Hey, that's all you need. You know, that just tells you that it's been securitized.
Okay.
On a court action, you can get that revealed. But they don't want to probably tell you, because really it's been securitized in some mortgage securitization trust, and once that's been done, it's bifurcated the note and the security agreement, and they can't foreclose.
And since it's a trust on their end, then they can choose to make that confidential and private. That they don't have to disclose who the who's claiming ownership of the thing, right? Because it's a confidential relationship.
Right. Well, at one time we had one that a case was coming at, the plaintiff was coming in, and it was actually the same bank as the lender. But I figured there ain't no way that the original lender is holding that original note. And practically today it's impossible. No bank, no lender is sitting there holding a note. They sold the note. And we searched around and we found out where that was true, because we punched in the MIN number in there and found out it wasn't them, it was Deutsche Bank.
Right.
Deutsche Bank is the one that was being held in trust. And somebody else was the servicer.
But usually in a foreclosure case, especially when it gets towards the end of the thing,
the interesting thing here, let me finish, was that they made come back that the mortgage servicer was the same bank as the lender, but they were not the original. They were the original lender in name only, because they sold the note, no longer having any right to foreclose, but only retained a servicing capacity. And in fact, maybe they weren't even servicer. They transferred the servicing rights back to them so they could come back in as plaintiff in this case, which made it look like they never sold the note, but they did sell the note. And as soon as we came in with the evidence that they sold the note, they backed out of the case. because they had them in a lie, had them in a fraud, because they were foreclosing in their own name when they had sold the note, sold the rights, and only transferred back the security, pooling and servicing agreement part for the purpose of coming at them and making it look like that they never sold the note. And they got rid of that case, got rid of that one quick.
I bet. Was that a Florida judicial case?
Yeah.
Oh, okay. No. Yeah, well, in this case, the lender of record, supposed lender of record, is one of those table lenders. You know, they don't lend anything. They're just some kind of originator who's out of business at this point. And I have a copy of the note that showed the endorsement on the last page of the note, and I've got proof that they stamped it, paid to the order of. But you don't see where it went. That they just show the stamp of them assigning it to whoever party. But I can definitely prove with that document that the lender of record assigned its interest a long time ago via that endorsement stamp. Who it went to, I don't know, but yeah, this thing's just ridiculous. This whole thing's just out of hand. NTT is the only thing that's going to fix this thing once and for all. I mean, I can do the at-law thing, but why bother?
Yep. So, any other questions?
No, that was it. Appreciate it.
Okay, thanks for coming on.
Thank you.
Hey, folks, if anybody got another question for Christian, go ahead and hit star 8 on your phone. It's about 10:15. So we got time for probably one more call, one more question. If you got a question, go ahead, hit star 8 on your phone, and we'll unmute you and give you an opportunity to talk to Christian. Well, Christian, doesn't look like we have anybody else who's got a question tonight.
Okay, that's good.
So if you want, we can go ahead and wrap it up.
All right, we'll do that there.
Okay, folks. Thanks, everybody, for joining us tonight. We'll be back here again next Wednesday night at 8 p.m. Eastern Time for another session of NTT New Trust Technology with Christian Walters. Christian, thank you so much. Everybody have a great evening.
Okay, thank you, Matt. You
Thanks,
too.
Christian. Have a great week.
Good night, everyone.
Good night, everyone.